Good afternoon, everyone. Thank you all for attending. I really appreciate you spending a couple hours with the judge and I to talk about ethics and professionalism. I've done this seminar annually for many years. This is David Golden. I'm an attorney with Troutman Pepper. I give this seminar primarily because one of my partners years ago, Jim Fleming, created a tax ethics outline. I think it's likely the only tax ethics outline perhaps in the state of Georgia. Therefore, whenever someone wanted an ethics presentation, they called on Jim, and when Jim retired, they called on me. The other reason I do this, I guess, is I was on the Internal Revenue Service Advisory Committee, goodness, almost 10 years ago, and was assigned to the Office of Professional Responsibility, and then got to kind of see the inner workings of that office. But thank you all for attending. Typically, when we do these, it's at the State Bar of Georgia. We do it in the afternoon and have a reception afterwards, because after hearing about ethics and professionalism for 2 hours, you certainly do need a drink. But nonetheless, because of the COVID, we've stopped doing that. We generally get about 60 people, 50, 60 at the most, to attend the seminars when they're in person. Today, I believe there's about 250 people at least that signed up, which one way to interpret is there are 190 people who are willing to sign up for the seminar as long as they don't have to be in the same room as I'm in, which I will try to not take personally, but nonetheless, it's the reality of where we are. Just want to take a minute to thank the State Bar of Georgia Tax Section, Jeff Cohen, the Atlanta Bar Section, Chuck Hodges, for sponsoring the seminar. It is because you are a member of these sections that you do not have to pay to get your professionalism and ethics credit, and thanks to both of them. We also have some law students from Professor Brewer's class at Georgia State, and thank you all for participating. We appreciate it. We are going to, here's just kind of a little preview of what we're going to talk about. I'm going to talk for an hour or so, then Judge Boudreaux is going to talk for an hour or so. I'm going to start a little bit with just going over a little bit of professionalism. I put in there conservation easements and micro captives, but really what I want to get into, I want to talk about those techniques because they're the hot button issues, at least certainly conservation easements for the IRS, but also just want to get into a little discussion about the state of the IRS, which, as you all know, is not great. In fact, it's downright poor. Avoiding tax malpractice, always good to avoid malpractice, right? Then I'm just going to do a basic ethics overview. It's been a couple years since I've done this, y'all. I resisted doing this seminar remotely because I don't like to be sitting at my desk talking to a computer screen. I much prefer being in a room with humans and interacting with them. But 2 years went by, and we still weren't comfortable doing personal in-house, where people actually live presentations. So here we are. I'm going to end with just Summa Holdings. Summa Holdings is just a case that I've grown quite fond of for reasons we'll discuss. It really doesn't have a damn thing to do with ethics, but I just like talking about it, and every opportunity I get, I do. Chuck Redding. Chuck Redding is the commissioner of the IRS and is dealing with all of the IRS issues. I just put on here all of his amazing accomplishments. He was a tax litigator with a tax firm in California, Beverly Hills, I believe. He was on ERSAC when I was on ERSAC. And ERSAC, by the way, is just Internal Revenue Service Advisory Committee. Anybody can apply. They have it's a 3-year term, 4 meetings a year. At least they used to be in person. I don't know if they still are with the COVID. And then ERSAC produces an annual report. I just sent in an application because I thought it would be interesting. Some of my colleagues encouraged me to do it. My kind of way to get in was the ethics, which is why they assigned me to OPR. But it's really a kind of a peek behind the curtain of the IRS, and you get to work with the highest level people at the IRS, including the commissioner. I don't know if there's anybody from Atlanta or Georgia that is on ERSAC today, but I think they start accepting applications around the summertime. And if you're interested, just send in an application. It is a very worthwhile, experience. But Redding's qualifications go on and on and on. It's kind of interesting that he was a tax litigator and he's kind of gone after techniques he likely would have been would have been litigating had he not gone to the IRS. But nonetheless, he's got a tough job to do, and I guess we can debate how well he's doing it. But the problem, as we'll see, is he really just doesn't have the resources to do it properly. Professionalism, the whole concept of professionalism really started in the late 80s with Georgia and the Supreme Court, the United States Supreme Court. To me, it is not, it's more than coincidence that in the late 80s, in the mid to late 80s, this upstart magazine called The American Lawyer, started by a guy named Stephen Brill, started to publish revenue results from law firms. Before that, folks, law firms obviously were not public institutions. We don't share the financials. Brill got the idea that that needed to be exposed, and the law firms, for better or for worse, agreed to do so. I traced the downfall of the legal profession to the American lawyer starting to share financial information about law firms. Just my opinion, but although it's interesting, the information that they shared, this, profits per partner, profits per equity partner, all that. If you really want to know, in my opinion, the most meaningful number for a big law firm, it'd be the median. What are the median income for partners? In other words, what is the income where half the partners are above and half the partners are below? That information, to the best of my knowledge and belief, is not shared. I think it would perhaps yield a different financial picture than what is in the American Lawyer. Just saying. Okay. A lawyer's creed, this is all, play nice in the sandbox type stuff. Chuck's going to talk about this in his presentation. It's really nothing anybody should have a problem with. To one extent, it's a little bit, I guess, sad that we've got to have a professionalism standard, but nonetheless we do, and we should try to adhere to it. Justice Clark, who was a justice of the Georgia Supreme Court, after he retired, he worked at Troutman, at that time Troutman Sonoma, but just a great guy. But he described professionalism as what is expected of attorneys, and ethics is what is required. And everything on here, faithfulness, competence, diligence, treat people with respect is, kind of common sense type stuff. And I'm dealing with the IRS and dealing with, at least with district counsel, chief counsel's office. I've never had an issue. Those lawyers are all pretty professional. With agents, well, perhaps not the same type of experience, but back years ago when we were downtown in the Kansas building, this firm, I remember there was a lawyer who had an audit of his pension plan years ago. An attorney could establish a PC and have their own little private pension plan, which didn't last very long. And the auditor came in, and this lawyer literally picked him up and threw him out of his office, which, while quite entertaining, was probably not very professional. So we should all strive to be professional. This is, I get into promoter, but to just kind of the state of the IRS and where the IRS is, it's, when I was on ERSAC, we produced a year-end report, and we recognized at that time that the IRS was woefully underfunded. They really couldn't compete in the very technical cases like 482 adjustments, where you needed to have experts. They just didn't have the resources. And 10 years ago, that was an issue. Well, over the last 10 years, it's just gotten worse. While there is a little increase in the IRS's budget, I think 6 or 7% in the budget that Congress just passed, it still leaves them far short of being able just to do their basic job of processing tax returns. And a couple of the service centers, Ogden, Utah, the one in Texas, maybe San Antonio, I'm not sure, are just a disaster. And I'm sure we all have stories. I've experienced this firsthand. I do one little 990 easy for a nonprofit client, and I filed that a couple years ago on paper because I wasn't hooked up to the electronic filing. You could file the 990 easy with paper. So I send it in, and I, FedEx it, get a confirmation it was delivered. And I also, whenever I send in a tax return or any item to the IRS, I like to get them to stamp it and send it back. And I include a return FedEx envelope. And by and large, they usually send it back. And so I got my little stamp from the Ogden, Utah Service Center saying we received your tax return. Well, then I get a letter, maybe, I don't know, 6, 7 months after I file saying we haven't received your tax return. And I'm like, well, okay, fine. So I put together a response, get my little power of attorney, and I send them the copy that they stamped. I send them the FedEx and say, look, y'all stamped it, you got it. Time goes by, and then I get a notice of intent to levy because I haven't paid because the organization has not paid the fine for failure to file the tax return. I'm like, So, and then at that point, it's a levy. So I do a collection due process hearing request, and I get that out, and I send it all over the place. And then I hear nothing from the IRS. Just the other day, I get a letter from the IRS that basically says, y'all, that they tried. Let me see if I can find my little letter. Here it is. This is a real letter. This is exactly what it says. It says, we previously sent you a letter about your inquiry. Although we try to respond quickly, we often need additional time for research. We can't provide a complete response at this time because we need more time to provide you with a complete response to your inquiry. Well, I sent them a friggin' copy of the tax return that they stamped. I don't know if they're doing like a forensic audit to make sure that they really, really stamped it, or if they're independently checking Federal Express to see whether it was really, really delivered like it said. But this is kind of what you get, and that's just the way things are with the IRS. And I know folks that are listening to this presentation have this or give the same stories. It's a nightmare. And you try to call, you can't get through. Years and years ago, you could actually call a service center and talk to a human. I don't think that's possible anymore, or at least they make it very difficult. It's very difficult just to talk to a human. The one strategy I've found, if you want to talk to a human at the IRS, is calling right when they open, like 7 in the morning. You may get through. The other day I called about something I can't remember, and I was on hold for like 3 hours, and then they dropped me. So, but a lot of it is just they don't have the budget. They don't have the resources. The government has made, and until they do, it's not going to change. And a little 7% increase ain't going to get it. But nonetheless, that's where it is. I want to talk a little bit about conservation easements and macro-captive insurance companies. As you all know, the IRS has gone after conservation easements with a vengeance. My understanding is there are as many as 700 or 800 docketed tax court cases whose issue are conservation easements. And the government has taken here, up to now at least, a very, very hard line against these cases. They offered a settlement proposal, which wasn't all that attractive to folks. I mean, basically, you could deduct what you put into it, and you get still have to pay a penalty. It's kind of a scorched earth approach. I'm a member of the Atlanta Tax Forum, and a fellow spoke last year. He's a former Sutherland partner who's gone to work in the commissioner's office and an advisor to the commissioner. And he essentially said that in the government's view that these transactions are fraud. They're fraudulent, that you've got promoters claiming that property they bought for $2 million is worth $8 million when they grant a conservation easement, and that's impossible and it's fraudulent. And look, if there are truly 700 or 800 of these things in the tax court, as there very well may be, I'm sure some of them have bad appraisals, but they all can't. And I don't know how the government is going to successfully prosecute 800 tax court cases. There was a decision. Well, they had some luck at the tax court invalidating these easements because of something called a proceeds clause in the deed. I'm not going to get in the weeds on conservation easements, but the proceeds clause basically says if the easement is extinguished, here's how, so that maybe a utility or someone comes in and condemns the property. So the easement is extinguished and they pay money for the property. Here's how we distribute the proceeds between the easement holder and the owner of the partnership that owns the land. And There was an IRS reg that came out that said, here's how you're supposed to allocate the proceeds if there's an improvement on the property made by the owner subsequent to the grant of the easement. So some improvement is made, the easement is extinguished, there's a certain way you're supposed to distribute the proceeds according to the IRS. Apparently, many of the early deeds granting the easement did not include the magic language with respect to these condemnation proceeds, and the tax court basically invalidated, maybe even some district courts invalidated the easement because they argued you have to be restricting the property in perpetuity, and because these condemnation proceeds clauses were not properly drafted, they didn't restrict the easement in perpetuity, and therefore the easement fails. It's the one way the IRS has to win these cases, because if it gets down to battles of appraisers, the government does not have the resources, in my opinion, to hire 800 appraisers, or even in-house have that many appraisals. They just can't fight it that way. So fighting using the condemnation proceeds clause was kind of a great way for the government's perspective to invalidate these. Well, lo and behold, the 11th Circuit comes along and determines that the regulation that established this formula for allocating condemnation proceeds, which the courts used to invalidate the easement, was invalid. And it's a good lesson that, although the IRS fought it for years, the issuance of regulations and the issuance of notices have to follow the Administrative Procedures Act. There's this whole litany of items that they've got to cover in order to follow the Administrative Procedures Act when they issue the regulation. One of those is you've got to consider comments, and you've got to demonstrate when you issue the reg that you have considered the comments. There were some comments with respect to this condemnation clause provision. It was something that was commented on, and the 11th Circuit says, look, IRS, when you all issued the reg, you were silent about any of these comments. Therefore, the reg's invalid. Now, that's the 11th Circuit. The 6th Circuit just reached an opposite result. So it will be interesting to see, if the Supreme Court takes it up, because at least in my lifetime, the Supreme Court has not embraced taking up tax decisions. So you've got to split there. But the whole point about these easements are, I remember when people, these were, seemed to me CPAs more so than lawyers were pushing these. I had several clients who asked me to review them. The conventional wisdom when they came out was that, well, maybe they'll be a little aggressive. Maybe the valuations are a little aggressive, and instead of getting, 4-to-1, you'll get 2-to-1. But as long as, you've dot your I's, cross your T's, it's going to be a battle of appraisers, and you'll settle it, and you'll still get something. So you might have to pay a little bit of tax and some interest, but you'll still be ahead by doing it. I don't think anybody, at least certainly not me, there may have been people smarter than me at the time, thought that these things could fall because of a clause in the deeds, but nonetheless, that's what happened. And the concern is, and the point I'm talking about all this is just that when someone comes to you with one of these shelters, ideas, tax savings, you just need to be careful what you tell them. And that, what I always advise folks is, look, maybe it works, maybe it doesn't, but what you need to do is put the tax savings in the bank, wait till the statute of limitations runs, and if it runs, have a party. But don't spend the tax savings, because there's a possibility it gets audited. There's always a possibility that there's an issue. I didn't see the deed issue. I thought it'd be more of an appraisal issue, but nonetheless, there's a deed issue. Our firm has not been involved in representing any promoters, defending any of these deals, but I have been approached by many, many investors. And what the government did, this is CID, the criminal folks, they sent letters out to investors in these partnerships. And although they weren't summons, they weren't subpoenas, they were letters. But here's what they asked them. These are people that invested in these partnerships that granted the conservation easement. And they ask, how did you learn about each investment partnership that resulted in your non-cash charitable donation? For referral, state who referred you to each investment partnership. They also asked, did you consult with any professional, e.g. accountant, tax professional, attorney, regarding the legitimacy of the investment company's conservation options? So they want to know, this is CID, the criminal division of the IRS, wants to know how folks found out about these transactions. Was it a CPA? Was it a lawyer? Was it some other advisor? Financial, whatever. And I believe the reason they are asking those questions is to see if they can tag a CPA or a lawyer with being a promoter and try to assess promoter penalties against the CPA or against the lawyer. So that's a long way to get to this slide as far as who is a promoter and is it something that we have to worry about. And I think the answer is generally going to be no, that if someone simply brings you an investment to review and you review it on their behalf, I don't believe you would be a promoter. You're not organizing or assisting in the organization. You're not really participating in the sale. You're just offering an opinion as to the tax consequences of the investment. And there's a fair amount. You also have to, in order to have liability, you've got to make a statement that you get a deduction, that income's excluded, that you know is false. So it's unlikely that any of us would be promoters. I just raise it because it's something to think about when someone comes to you with a tax saving strategy. I suspect when these first came around that nobody thought they would be widely used as they were. I don't think folks thought there'd be 800 tax court cases docketed. I don't think people thought there'd be proceeds clause that potentially invalidated. So just kind of be careful, hedge your bets when folks come to you with these. And I know I started to get nervous about them. There's a magazine called Garden and Gun, which is an interesting juxtaposition. I picture this guy with his gun guarding his garden. Anyway, Garden and Gun had a little classified ad on one of its pages touting a conservation easement and some sort of 6-to-1 write-off. It's always been my theory that when you see an ad for a tax shelter in a kind of a document, in a magazine or the Wall Street Journal, whatever, that means you run like hell because something ain't right. And when people are making it that known, the IRS reads those. But back in the 80s, when I first started practicing, there were big articles in the Wall Street Journal about single premium life insurance contracts. And at that time, you could fund a life insurance contract with really unlimited amounts of money. It'd be treated as life insurance. You know, life insurance gets favorable tax treatment so that any inside buildup in an insurance policy is not taxed. And then you can kind of borrow the money out, never pay any tax. Well, these things were touted in the Wall Street with these big ads in the Wall Street Journal. And, you know, who reads the Wall Street Journal? Well, the IRS. And sure enough, after about a year of these ads and insurance companies probably making a ton of money setting these things up, Congress came out and created something called a modified endowment contract. It said if you upfront load a life insurance policy with too much income, more than is needed to support the policy, it's a modified endowment contract. And if you borrow money against that policy, it's income. And that was all because it's the old pigs get fat, hogs get slaughter theory, and the life insurance industry got a little bit too hoggish, and the technique was pretty much put to bed. So the point is just if you're reviewing these type tax saving strategies, just make sure you're careful, make sure you're in no way can be a promoter, and just, you know, obviously you give your best estimate as to whether it works or not, but the whole point is just to be careful. You don't want to be a promoter. Okay, as we're moving on, we're just going to kind of skip some. I want to talk a little bit about avoiding tax malpractice. I borrowed this from an article by a fellow named Kip Dellinger. As you can tell, I stole the outline from Jim Flynn with his permission. I only really borrow from the finest people. And Kip Dellinger is a writer, a CPA, I believe CPA attorney, writes for Tax Notes, and had a really good article about avoiding malpractice. And I thought it would just be something that's worth talking about today. Well, I hope and pray no one on this in the seminar has any issues with malpractice. And he highlights that one of the largest reasons for malpractice are missing deadlines. Deadlines can be tricky in the tax world. They're not only deadlines that come with filing tax returns, but there are other deadlines, like an 83B election. An 83B election deadline is 30 days from the day you receive the property. It's not tied to any sort of tax return. So you've got to be real careful with deadlines, and they can bite you when you might not expect it. And the one fortunate thing about deadlines in the tax world is if the deadline is established by a regulation rather than by the code, you've got 9100 relief where you can grovel before the IRS. If you meet certain criteria and pay a bunch of money, the government will waive the missed deadline and grant forgiveness. The problem with 9100 relief is it's very, very expensive. I think it's thousands of dollars now. Back in the day when I first started practicing before the internet, you didn't have to pay anything for like private letter rulings. And I think the average cost of ruling is now $30,000, just the filing fee. So 9100 relief is expensive. If it's a deadline that was missed because we did something wrong, well, then that means we're paying the fee. And it's at the IRS's discretion, so there's no certainty that they'll grant it. Although my sense is that the IRS is fairly liberal, especially like Section 54 elections, Miss elections. There's some pretty well procedures that if you can follow, you'll get relief. But nonetheless, just make sure you're careful about deadlines. Bad advice. Clearly, that's an issue. We've got to make sure we give good advice. And when I was on ERSAC back in 2012 to 2014, we have actually amended Circular 230. We'll talk about this in a little bit to provide for a competency requirement. Before we did that, there was nothing in Circular 230 that required that an attorney be competent. And we felt like that was kind of a basic fundamental of practice before the IRS. You need to be competent. And now it's embodied, as we'll see, in Circular 230. And bad advice, it's not only formal opinions. You're giving advice when you draft an email. You're giving advice when you draft a memo. And typically, I know at least with me, certainly, I don't give probably enough thought to sending out emails, and certainly than I would if I was giving a formal legal opinion. But as we'll see, the ethical considerations for both are the same. So just when you give advice in any sort of form, even orally, just think about it and make sure you're giving good advice. One of the things I was taught early on in tax practice was, unless the question is as basic as does the United States have an income tax, you really don't want to give tax advice off the cuff because A, the code is incredibly complicated and complex. B, the advice typically may vary depending upon the facts. You want to make sure you have all the facts and understand them. And people like to, well, what do you think? And I really resist giving advice without having at least the ability to think about it or to research it. Dellinger mentions quality control. You should choose clients carefully. Clearly, you got to make sure, because you don't want to get a client who's a bad actor. Make sure you're competent. You need to have engagement letters. Troutman Pepper will not open up a file unless I have an engagement letter, which means I can't bill any time unless I have an engagement letter, which is quite frankly, a very powerful incentive to have engagement letters. Tickler systems and checklists, big believer in those. I've got checklists for here's the steps you have to follow for an A reorganization. Here's the steps you have to follow to make an elected small business trust election for a trust, or those type things can be invaluable if you have them, just to make sure that you've got your bases covered. A real problem can be conflicts of interest, and you can see that if you're representing a husband and a wife. Also, entity versus owners. Are you representing the entity? Are you representing the owners? Firms have gotten into trouble because it wasn't clear who they were representing. Were they representing the entity or the owner? Obviously, your duties are very different if you're representing an owner than if you're representing the entity. You can make that very clear in the engagement letter, and but that is an area where you see a lot of malpractice claims. And also emails. It's so easy to get an email and respond and give some advice, and you just have to really think long and hard before you send an email with tax advice, just because, as we'll see, the ethical considerations for sending an email, for giving a formal legal opinion, for drafting a memo are the same. The law doesn't distinguish among them. If you're giving tax advice and it's in a written form, you're subject to ethical considerations and professional competence. Notwithstanding that's an email, and you might have put, just because it's an email, less thought. So be very, very careful and thoughtful when you send emails out. I know there's at least one accounting firm that I'm aware of that in their engagement letter takes the position that you cannot rely on an email for tax advice. I don't know if that's really enforceable, but nonetheless, that's the way some people try to deal with it. I know other people who will wait a couple hours before they respond to an email with tax advice just to make sure they thought through things, but just be thoughtful. That's the point. Moving on, we're going to skip some of this because otherwise we'd be here all day. We don't want to be here all day. I was going to talk about Sumo Holdings at the end. I'll just talk about it now, just because I've embraced this case, y'all. And it's a case involving a Roth IRA, and it's a way you can get like millions and millions of dollars in a Roth IRA. It was upheld by the Sixth Circuit by Judge. The only reason, though, I've embraced this case is because this is the only reported tax case. It came out in 2017. Just Google Sumo Holdings, it'll turn up. It is the only reported tax case I'm aware of that cites to Caligula, who was a Roman emperor. And if you're younger than I am, which 95% of you are, and aren't familiar with Caligula, just Google Caligula in 1979. And that'll tell you. In any event, this case actually cites to Caligula. It is a fascinating opinion, which really scorches the government. They set up this structure with this Roth IRA, where the Roth IRA accumulated literally millions of dollars. And while it paid a little bit of tax accumulating the money, it's a Roth IRA, so all the money it accumulates tax-free, makes distributions tax-free. The government didn't like it. The Sixth Circuit, though, and then the government tried to argue a substantive reform argument. The Sixth Circuit rejected it, but it's to cite Caligula in any sort of legal opinion, let alone a tax opinion, was just unbelievable to me. It starts off, Caligula posted the tax laws in such fine print and so high that his subjects could not read them. That's how it starts. How can citizens comply with what they can't see? Any event, enough about Sumo Holdings and Caligula, but you ought to read that opinion because it's fascinating. And I guess it still may work. Okay, moving on. Let's talk about Circular 230. Circular 230 is kind of rules of the road, the rules that govern attorneys, CPAs, enrolled agents in dealing with the IRS. If you have not heard of Circular 230, you need to just Google it. It's on the IRS website. Back when I was on URSAC, we did a little summary of it that's available. I think it's still up there at least. And it governs how you deal with the IRS. And it's enforced by the Office of Professional Responsibility. The Office of Professional Responsibility around the IRS for years and years. It really didn't come into play until the early 2000s when the big four accounting firms, however many accounting firms there were, got a bunch of really, really smart people in a room and decided that they were going to figure out ways to satisfy the literal language of the code and generate transactions that resulted in incredible deductions for taxpayers, which have no economic substance, silos, lilos, all that good stuff. And that really triggered the IRS to reinvigorate OPR. There was a guy, Kono Numerati, who was really the one back then who kind of reinvigorated OPR and made it a meaningful division. It's like appeals, it's independent. When I was on OPR, Karen Hawkins, when I was on URSAC, Karen Hawkins was the head of OPR. She had big plans for OPR. She was going to open up offices throughout the country. She went after those firms. You hear the ads all the time. Let's say if you owe $10,000, pay penny on the dollar. She went after them with a vengeance, and she really got a lot of them to tone down the ads. If you think about those ads 10 years ago compared to what they advertise today, they're very, very different. That was a real focus of Karen. She tried to go after some attorneys. She went after a big firm. I can't remember the exact name. It was one of the big New York firms over a bond opinion, which was quite unusual for OPR to actually go after lawyers for an opinion that in OPR's view rose to the level of violating Circular 230. The problem that OPR had and probably still has is the lawyers that litigate those cases for them are part of general legal services from the government. They're not necessarily they're not tax specialists, and they just got outgunned, and she lost that case. But nonetheless, she was very, very aggressive with OPR. And in fact, the reason I was on URSAC because there was a whole separate unit dedicated to OPR. Over the years, since I've left URSAC, that's now changed. URSAC doesn't have an OPR section anymore. It just gets folded into the other work. After Karen, there was her deputy kind of became head of OPR. Then, interestingly, they appointed someone as head of OPR who wasn't an attorney, which was kind of interesting since they bring cases against accountants, lawyers, whatever. Based on the IRS website, at least the current occupant head of OPR is an attorney, which is certainly a step in the right direction. And if you never hear of OPR again, that's a good thing, because if you do hear about them, it's likely not good. One of the things that when I was on URSAC, just worth a brief mention, is the IRS tried to regulate tax return preparers who were not CPAs, attorneys, or enrolled agents. They believe at the time, and I think it's probably still true, that there is massive fraud, especially with earned income tax credits, where you've got unscrupulous preparers who file returns, put enough income on the return so that the person gets a refund. It's a refundable credit. And they felt like that was just a huge problem, and they had to figure out some way to regulate tax return preparers. And they had an agency, had a whole different office, return preparer office, to regulate preparers. They hired one of the consulting firms to develop a test. They were going to require that if you were not a CPA, attorney, or enrolled agents have to take a test. If you're not an attorney or a CPA, that you would have to take a test to sign tax returns. Spent, I believe, millions of dollars figuring out how they were going to regulate tax return preparers who are not otherwise subject to Circular 230. And that's when PTIN started back then, as a way to track people. So they're going about kind of putting all this money in, enacting all these new standards, and apparently, at least when I was on there, nobody talked about it. And this is just what I've got up here now is what is the practice before the IRS. But apparently, no one stopped and thought, gee, we're the IRS. Do we have the authority to regulate people, tax return preparers, that are not CPAs, enrolled agents, or lawyers. And no one really thought about that. They were spending these millions and millions of dollars and trying to regulate these tax return preparers. And a bunch of preparers got together who were not CPAs, not attorneys, not enrolled agents. In the case Loving v. Commissioner, the DC Circuit essentially held that filing a tax return is not practice before the IRS, that the IRS can regulate practice before it, and does that with Circular 230, but filing a tax return is not practicing before the IRS. And why? Well, because you file the tax return on your own. We have a system of voluntary compliance. Everybody files their own tax return. The IRS doesn't come knocking on your door and sit down with you to file your tax return. You do it on your own. Because the IRS really doesn't participate in that process, or at least there's no requirement that they participate in that process. If you are simply preparing someone's tax return, you are not practicing before the IRS, and therefore the IRS does not have the authority to regulate you. That's the Loving case. And to this day, it's, I'm just kind of moving ahead a little bit. Here's Loving. To this day, it's the law. And since Loving, the government has tried to get legislation passed so that there would be some ability to regulate tax return preparers that are not otherwise regulated, and they've had no luck getting that legislation through. I think when President Biden was in some of the Build Back Better legislation as part of the enhanced funding for the IRS that people really fussed about. But as part of that, I believe there was some provisions in there to perhaps regulate tax preparers. But to this day, 7, 8 years ago, to this day, there's no authority for the IRS to regulate tax return preparers that are not CPAs, attorneys, or enrolled agents. This is just kind of interesting. It shows you what goes around comes around. This is back in 2014, where OPR went after appraisers of facade easements. So I guess it shouldn't be surprising that in 2022 they're going after appraisers of conservation easements. A rich tradition in the IRS of trying to go after appraisers. We'll skip some of this because this is all the legislation that has been proposed to regulate tax return preparers. None of it's been enacted. I now just want to do just a basic ethical considerations of tax practice. Just because I haven't done it, this is a presentation in a couple of years for a bunch of new people that are listening. And thank you very much again for attending. So what are the ethical considerations? There's ABA opinions, ethical canons of ethics. The AICPA has their own called Statements on Standards for Tax Service, kind of the corollary of ABA opinions in Circular 230, statute, civil and criminal, and particularly penalties. And one thing to always keep in mind when you're advising a client based on the tax treatment of a transaction is, most folks are fine if they have to pay a little bit of extra tax, and maybe they have to pay a little bit of interest, particularly in the low interest rate environment we're in now, but they kind of balk at paying 20, 40, 80, 100% penalties. And it's very, very important, I think, in satisfying your ethical duty that you always advise clients of the possibility of penalties in the event the IRS successfully challenge a transaction. The ABA acknowledges that there are different standards for tax practice depending upon the role of the attorney. If you're planning, you might have more of an obligation to make sure the client is aware of weaknesses in the position, make sure they understand the risks. If you're a preparer, you may have an obligation to tell the client about disclosure and the fact that disclosure may result in penalties being waived. Whenever I advise disclosure on a tax return, my response is usually, well, that cause my return to be audited. And I'm like, well, what do you think? That's why they want you to disclose it. But as we'll also see, you can't advise clients based upon the audit lottery. But nonetheless, you may have an obligation to advise disclosure for no other reason to avoid penalties. Very different situation when you're advocating a position. Much more way to zealously represent your client. And of course, tax shelters, public offer, you got public reliance, which heightens up the requirements. ABA Opinion 314 was way back in the 60s and was one of the first ABA opinions dealing with ethical considerations in tax practice. It's viable in the advocacy context. It recognizes that obviously dealing with the IRS is not like dealing with an impartial tribunal. The IRS is not impartial. They talk about this more zeal. Notwithstanding all that, you have a duty not to mislead. If a client misleads without your knowledge, you need to take that consideration, determine whether you can, you don't want to breach any client confidences, whether you can continue the engagement. The standards for giving tax advice in ABA 314, in other words, what's the minimum bar tax advice has to meet in order to satisfy ethical considerations, was a reasonable basis. As long as you had, this is the ABA opinion back in the 60s, as long as you had a reasonable basis to reach an opinion as to the tax consequences of a transaction, you had satisfied your ethical obligation to the system. And if you had a reasonable basis, you had no duty to disclose. That it was thought to be an incredibly low standard. It was widely criticized. As a result, some 15, 20 years later, ABA Opinion 352 was issued. 352 established a new standards for a minimum bar that tax advice has to meet. And it's a realistic possibility of success if the matter is litigated. If you have a realistic possibility of success, you can ethically give the advice. You're satisfying your ethical criteria. It's 1 in 3, and that's by statute. Now, just because you've satisfied realistic possibility of success and meet that standard doesn't mean that your client may not be subject to penalties. They very well may be subject to penalties because penalties has a higher standard, substantial authority. But if you give opinion that a transaction has a realistic possibility of success, you've met your obligation to the system. The one constant in giving any tax advice, and you'll see this in the attorneys and the lawyers, is you're not supposed to consider the audit lottery. That is, and it's difficult, but the concept, it's difficult because nearly every time I give advice and say, well, you've got exposure here, you've got exposure there, invariably the next question, next statement from the client is, what are my chances of getting caught? What are my chances of getting caught? And you can't advise based upon a client's chance of getting caught. It's simply not ethical. We do have this voluntary compliance system. If everybody kind of tries to rely on the audit lottery, the whole thing falls apart. So, now look, back in the 90s, the older people that are listening to this, and I consider myself one of those, is the IRS was reorganizing. The government before the late 90s was organized, the IRS was organized geographically. In the 90s, they changed to organized on business unit, small business, large business, whatever. During that reorganization, they moved many lawyers from the field into the office to help with the organization. Quite frankly, that was probably the golden age of tax cheating, no pun intended, because they had moved so many people into the office to affect this reorganization that they stopped auditing, especially small businesses. But that was 20 years ago. In any event, you can't consider the audit lottery. It's tempting. What I tell clients is, look, if you want to play the audit lottery, you don't have to pay my billable rate. Just go ahead and file your return and take your chances. Also, I mentioned this earlier, you've got to advise clients about potential penalties. That's in the ABA opinion. It's very, very important. Penalties can be significant. You don't want your client to be caught by surprise. You want to make sure that they're aware that, look, this goes south and the IRS succeeds, you're going to pay the tax, you're going to pay the interest. and you may have a penalty unless we can figure out a way to abate it. That's ABA Opinion 352. ABA Opinion 351 talks about confidentiality versus disclosure in a fraud context. I've rarely seen fraud in my career. About the only time I was concerned about fraud was when a client, it was an old accumulated earnings case years ago. And I'm sure the government is making these cases where the allegation was they were impermissibly accumulating earnings inside the corporation, obviously a C corporation. And one of the ways you can defeat that allegation is to demonstrate that there was a business purpose for accumulating the earnings. There's a reason you did it. You were planning some expansion in your plant, planning an acquisition, whatever. And I told that to a client, and the client all of a sudden one day shows up with minutes of a meeting where they list all these reasons why they had accumulated these earnings, and it was dated a couple years ago. And to this day, I'm not sure whether that was real or not, but nonetheless, that's the only time I've really had to even kind of thought about fraud. If the client, you should urge the client to rectify the fraud, and I hammered this person, and they claimed that the minutes really were dated a couple years ago, that they didn't just create them, that there really were meetings. And if the client refuses, you may have to disclose it unless it's privileged. Hopefully you don't have to deal with that. There's ethical consideration 7.3, which recognizes the distinction between being an advisor and being an advocate. With an advisor, you have the potential to shape future conduct, which is why you want to make sure you give the pros and cons, the weaknesses, the strengths of the position. And in an advocate, obviously, you're resolving all doubts in favor of the client. Pretty straightforward stuff. The AICPA, I know we all work with CPAs, have the same ethical standards as lawyers do. Realistic possibility of success, advise of penalties. Once again, don't exploit the audit lottery. Not frivolous if it's adequate, type 1 there, not frivolous if it's adequately disclosed. It's a lower standard. If you disclose, you have a much lower ethical obligation. It's the same as true with lawyers. It's as low as not frivolous as long as you disclose. This is just a helpful little chart that describes the various standards for tax advice and the probability of prevailing. At the top is will, which is 95%. I'm not a big believer, although I know in some industries, will opinions are standard and expected. To me, will sounds like the law firm is an insurance company. I don't think law firms are insurance companies. Therefore, I'm not real keen on giving will opinions, although I've given them, and in circumstances the industry expects them. And will is pretty much a 95% plus confidence level. Should is typically an opinion that we're much more comfortable giving, 70% plus. And those are just kind of percentages based on, they're not codified anywhere, just kind of percentages based on practice. More likely than not, 50.1, substantial authority, less than more likely than not, but more than a realistic possibility of success. And substantial authority can be private letter rulings, notwithstanding that they're not binding precedent. They can get you out of penalties. And reasonable basis, very low, and not frivolous, incredibly low. If you disclose, you can have a fairly low standard. This is the ubiquitous Circular 230 disclosure that 10, 15 years ago used to be on everybody's emails. The reasons this was on everybody's emails, because at the time, the IRS, in Circular 230, in response to all the tax shelters in the late 90s, developed all these intricate rules about opinions, and they had to have be in certain type, had to include certain language, had to be in a certain format, and you basically had to inform people that if you didn't meet the standard format, it was called a covered opinion, that you couldn't rely on any tax advice. That was this was stuck on every email for years. I still see folks occasionally have this on their email, It is no longer applicable. There is no requirement in Circular 230 that you include this. In fact, you shouldn't include this because it's not right. The whole regulation of written tax advice has changed. Most people have eliminated it, but I still get a couple emails with it on there, and it shouldn't be. You should take it off because it doesn't apply. The competency requirement of 10.35, as I said, this came about when I was on URSAC, and we just thought that, gee, that's something that ought to be embodied in the circular. You've got to be competent, knowledge, skill, thoroughness, preparation. We acknowledge that you can gain competency through study, but nonetheless, Circular 230 does establish a baseline competency requirement. If you're giving tax advice, you need to make sure you're competent giving that advice. Not that that's a problem for anybody on this call, but nonetheless. Circular 230 does have procedures. If you are the head of a tax department in a firm, there are rules that apply to you as the head of a tax department. You've got to ensure that the firm is in compliance, that you've got procedures in place. To ensure there is compliance, you got to make sure that people are satisfying their filing obligations. As we'll see, the easiest, the lowest hanging fruit for OPR and violation of Circular 230 is for a tax lawyer not to file their tax return. That will get you into trouble. That's the lowest hanging fruit, because obviously the government knows who's filed, who hasn't filed. If you don't satisfy your filing obligations, you can get suspended from practice before the IRS. Circular 230 does govern written tax advice, although it's not really clearly defined in 10.37, but what is tax advice? And it's really just applying the law to specific facts. If you're just giving a general explanation of a provision of the code, here's how you do like-kind exchanges. You identify the property within 45 days. You close within 180. You use a qualified intermediary, sign contracts, all that. That's generally not going to get you into hot water if you have a misstep, because that's not tax advice. It's when you're applying that does a particular transaction qualify for like-kind exchange treatment, that is tax advice, and that's when you're under the Circular 230. And if the client intends to rely on the advice reporting a transaction, clearly that's covered, right? And the client reasonably believes that they can rely on the advice. And here is the requirements. This was new several years ago, but it's very, very simple. These are the requirements for any written advice. And this replaced page after page of detailed requirements for written advice. I talked about covered opinions, not covered opinions. This is what now we have to follow, and it's pretty straightforward. You have reasonable factual legal assumptions, consider all the facts, use reasonable efforts to identify the facts, don't rely on third parties if that reliance is unreasonable. And that's where you may be able to get some of these opinions in conservation agents if they relied on appraisals that were unreasonable. Relate the law to the facts, and once again, do not consider the audit lottery. If you remember nothing else about today's presentation, then do not consider the audit lottery. I will consider the presentation to be a success. And that's it. That's what you need. That if you meet this criteria, you've satisfied Circular 230 with respect to written advice. So it's a pretty straightforward, streamlined requirement. You can rely on third parties as long as you don't have reason to know that there's something bad with what you're trying to rely on. When the IRS is reviewing opinions to determine compliance with Circular 230, they're supposed to take a reasonable standard considering the scope of the engagement, the type of advice, obviously a higher standard if it's a tax shelter. And just remember, this applies to written advice. An email is written advice. And just be careful when you're sending out emails to make sure you've thought through them, that you've, qualify it saying, look, this is preliminary, I haven't done any research, here's some initial thoughts type of thing. Because if you give bad advice in an email, that bad advice is treated the same in an email as it would be in a formal written legal opinion or a memo. So just be careful. Let's see. The other thing I just wanted to talk about is filing tax returns. If you are going to practice before the IRS, you got to file your income tax return. Failure to file a return is one of the easiest ways to lose rights to practice before the IRS. It's automatic if you do it 4 out of 5 years, 5 out of 7, but just make sure if you're going to be a tax lawyer, you need to make sure that you file your tax return. Even if God heaven forbid you can't pay the tax, file the tax return. They're not going to penalize you if you can't pay the tax. They are going to penalize you if you don't file the tax return. I have now used my allotted hour. I am now going to turn the presentation over to the Honorable Judge Boudreau. I'll have you know, Judge Boudreau, I have prepared an introduction for you. I was not going to make you introduce yourself as I had to do, which was fine. No, so I shall give you a proper introduction. Judge Boudreau was a senior partner for years and years at Morris, Manning & Martin. We were contemporaries, and we kind of came up at a time when tax lawyers, rather than specialists, were kind of generalists. We learned how to do a little bit of everything, which I think served us well over the years. In 2012, Judge Boudreau left Morris & Manning for government service. He was tapped by Nathan Deal, Governor Deal, to be the first judge of the Georgia Tax Tribunal, and helped establish, did establish the tribunal, established all of the administrative procedures for dealing with the tribunal. It was a huge job, which we are certainly indebted to him for performing. I believe, at least according to the website, Judge, you had over 2,000 opinions, including some very, very, very important ones, and particularly at the Rosenberg versus McGinnity, which dealt with the Georgia partnerships holding in multiple states. There's also an opinion about whether you're a Georgia resident. It's kind of a seminal opinion when you're, for tax purposes that you should read. But the one thing about Judge Boudreau you may not know, you may not know is that he's also a musician and a composer. And at least according to this little blurb, was associated with 2 of Atlanta premier choral groups, Choir of the Cathedral of St. Philip's and the Choral Guild of Atlanta. Composed over 40 works for chorus, organ, and brass, and for chorus and chamber music. So a true Renaissance person. I give you now the Honorable Charles Boudreau. Thank you.
Well, David, it's nice to get to hear your speech again. I'd forgotten.
Thank you. I wish it was in front of humans instead of in front of the computer. I'm going to stop my speech here.
I hope and Elaine, I hope you're listening. David, I hope at some point I'm going to probably ask you some questions and want you to chime in as we go along.
Delighted.
But we'll finesse this, and I don't know how. I'm sure many of you. I mean, I don't have to do CLE anymore, except with your judge, you still have to do CLE. So there's some things that you just can't get out of. So it's great to be here today. It's good to be in touch. It's great to see David. I mean, as I say, I have no old friends, but I have many friends of long standing. So I'm going to talk a little bit today about professionalism in the administrative practice, which of course, my paper is going to be, my paper that's been distributed is, again, and as David said, we've done this shtick before. Hope to add some updates that will be useful to some of you and interesting. But after I did the tribunal from 12 to 15, I went back to Morris Manning for 3 years. Interestingly enough, Judge Michael Malahy, Chief Judge Malahy, who is the Chief Judge for the Office of State Administrative Hearings, is just if you look up public servant in the dictionary, it's going to have his picture. I mean, Judge Malahy is one of the best administrators and one of the most dedicated public servants I've ever seen. But Judge Malahy, in a sort of interesting kind of way, when I went back to Morris Manning, he said, well, would you like to keep doing some cases for us part-time? And I talked to Louise Wells, who was then the managing partner at Morris Manning, and she said, sure, it'll be good for us. Anyway, I did it and continued to enjoy it. And then when I retired from Morris Manning the second time and was told I did not get another retirement party, but I went back to OSA. Now I've been working for OSA part-time for the last 3 years as administrative law judge, and it's been very rewarding. And it has given me a wonderful sense of perspective, I think, on the whole practice. And yes, David and I, unfortunately, are old enough to, there's a tendency to want to say, well, where are the snows of yesteryear, and everything was better in the old days, and they weren't better. But what you do see is you see things that have happened over time. And one of the great things about David's presentation is he does the historical perspective. And you cannot understand ethics and professionalism unless you understand the history. What is it? I think it was Frankfurter said, what is it? A page of history is worth 1,000 pages of logic. You have to know how we got here. And we've gotten here because there is a dialectic. I often used to tell my students at Emory when I was an adjunct over there, I would laughingly say I'm one of the few remaining Marxists. And everybody would look at me with shock and dismay. Not Marxist in the sense that, Lenin and Stalin, but in the sense of, if Marx, Marx was actually his theory of history was economic determinism. And to a considerable degree, I subscribe to economic determinism, that if you want to understand history, you have to understand economics. Well, if you want to understand the ethics and the professionalism of the legal practice, you have to understand economics, otherwise known as follow the money. And it should come as no surprise that we have issues because people follow the money. And the evolution of ethics, and to a lesser degree professionalism, have been about responses to abuses chasing money. When David and I were kids, the latest tax shelter was a thing called a butterfly straddle, which involved offsetting positions in currencies, which could generate guaranteed it could convert capital gain, ordinary income to capital gain and defer the ordinary income. Everybody who looked at it and had any sense said, this is too cute to work. There were a lot of people who believed it. They did it. The IRS went after it. There were some very prominent law firms in Atlanta, very prominent lawyers who got their hands spanked. That blew up. Then we lived through the 70s when we dealt with tax shelters. And I knew I should have known the days of tax shelters were numbered when in 1985, I invested in my one and only real estate tax shelter. Well, in 1986, we got the Internal Revenue Code, we got passive activity loss rules. And, Congress, when they want to kill something, they kill it. And they did. But the IRS began to go after lawyers and accounting firms because of alleged abuses. You may remember a little firm, it was Jenkins and Gilchrist, which was eventually put out of business because of alleged tax shelter work. And then in 88, of course, we had the savings and loan collapse, which was driven entirely by the collapse of the real estate industry, which was driven entirely by the 1986 tax code, which any idiot who knew any economics knew that when you outlawed passive activity losses, you were going to reduce the value of real estate by about 20%. Not surprisingly, that happened. Not surprisingly, we had massive recession in 86 and 87 and 88. We had the real estate liquidation. And then we started getting law firms. And then the only thing the Resolution Trust Corporation succeeded at was suing law firms and accounting firms for bad legal work. So that happened. And again, Circular 230 and all of these things arose in this background. Well, and my little sermon on, David's talked about the conservation easements. Why have conservation easements been such a problem? And why is the service being so absolutely unreasonable with it? And the reason is, as David very correctly said, the government is outgunned. People think, and you'll listen to Congress, and sometimes you'll get the sense that, oh, there's this huge bureaucracy out there. Well, the reality is that the government is to some degree a paper tiger. The only people who really have to confront the government are a very, very small percentage of the population. So the government is unable to audit returns. I think the audit, I don't know what the latest numbers are, David, you may know, but gosh, the last time I looked, it was about 0.7 of tenths of a percent, 0.7.
That's right. It's incredible.
Yeah, it's incredible. And they don't even audit them unless usually those cases originate because there's something that is like blatantly obvious, like an omitted 1099, or better yet, where do almost all tax audits and tax cases, enforcement cases come from? They come from unhappy former employees and unhappy former spouses. The reality is that unless there's something like that, the government is not going to go looking, unless you're just the poor schmoo who drew the wrong lottery ticket and you get looked at. So to go back to the issue about conservation easements, the problem is the pattern, if you look over the last 30 years, is whenever we have a tax abuse, is eventually the government tries to lock a few people up. And it's sort of under the heading of, well, we're not going to be able to do a lot of people. Maybe if we have a few public executions, that will deter conduct. I think those of us who have been in the tax practice this long know that's a vain hope. The only way to ensure compliance is swift and consistent enforcement, and that is not in the cards. We are in a frighteningly wild west in terms of of tax compliance. Now, there is one exception to that. And again, this is interesting because one of my good buddies, who's a young tax lawyer, defined as somebody who's less than 60. Good guy, fine tax lawyer. He said, what we all need is more audited clients. Because when you really get into it, interestingly, tax compliance is now driven not by the IRS, but it is driven by the auditors who basically have to stand by the tax reserves in the returns that they file and the financial statements they advise on. So if you're an audited client, you're going to be very careful. But if you're not, you tend to be a little slack. Again, I'm not trying to say things were better in the old days, but at least on the enforcement side, the good thing about the service in the old days, there was some equity in the enforcements. Now, the enforcement is so arbitrary, it's almost counterproductive. Anyway, enough of that rant. By the way, David, my offer still stands. If they want to hire me to come to Washington and lock up lawyers who don't file their tax returns, I'll be glad to take the job for free. I find. Let them know. What was it, Ms. Hawkins, that wanted to do that? I think.
Oh yeah, absolutely, she did.
Yeah. It's a tragedy. I mean, the fact that there are lawyers and accountants out there who don't file their tax returns and who are permitted to walk the streets is just, and then you wonder why people don't take the tax system seriously. All right, enough. I've ranted for the moment. Now, I do want to follow up another thing with David, though, that bears repeating. Again, based on personal experience, based on knowledge with clients, the IRS really is reeling. And their ability to do things is frightening. I have some similar stories to the one David told. Literally, you can't get to the right person. For years, I used to say, before I went to the Tax Tribunal, that my experience with, and fortunately, by the way, the Georgia Revenue Department is not in the condition of the IRS. The Georgia Revenue Department they don't have an excess of resources, but they're still functioning. And they still have some competent people, and they still try to get stuff done. The good news is that and this is my observation about the tax tribunal. I think the great accomplishment of having the tax tribunal is, and I believe Judge O'Neill would concur with my statement on this, is that the tax tribunal has done two things. It has created basically, as I used to say, it's the trooper that's parked on I-85. So everybody slows down because they know they're being watched. Well, in the case of the tax tribunal, it's both sides, but it's particularly, quite frankly, the Revenue Department, because the Georgia Revenue Department, before the institution of the tax tribunal, if it had one failing, and I think one source that was consistently a legitimate criticism, is it would sit on stuff. It just, when it didn't like the answer, it would sit on it. Well, creation of the tax tribunal made that impossible, because now people, if you have a tax problem, there is a way to force the issue. Again, David and I are old enough to remember, and I will use his name. I'm sure he's retired. He may be deceased by now because he was, we were kids back then, but Mike O'Brien, when he was head of the corporation's tax division, we would have cases, and if Mike didn't like the answer, he would just sit on the case. And eventually, the taxpayer would say, I've had all the fun I can stand. Let's settle the case and figure out what we need to pay to get out of it. That is no longer the case. That kind of behavior won't work now. And the reason it won't work is because you go to the tax tribunal. So let me talk a little bit about the tribunal. One of the things a lot of people don't realize, and this is also true of OSA, the great thing about the tax tribunal and the great thing about OSA is it is a way to, in effect, get to problems resolutions when all else fails. Because if you end up in an administrative law court, there is a judge who will at some point look at the parties and say, now tell me again what we're arguing about and why is this matter not resolved. Now, that is particularly true in the tax tribunal. I don't have the stats, but if historically, and I believe this is still very much the pattern, a large percentage of the tax tribunal cases are just good old-fashioned goofs. There are things that don't get credited. And by the way, that is one of the biggest and most recurrent problems that affects all revenue sources. Credits, the lack of getting things credited properly. A lot of times, and in that regard, and David mentioned my case that we did on the multi-state taxation of flow-through entities. In Georgia, one of the things the department struggles with mightily, and they will tell you this is not a deep dark secret, is tiered entities and tiered entity credits. It's very, very important if you are dealing with tiered entities and tiered entity credits that you make sure that the people who've done the filings do it correctly, because otherwise they'll deny it because they won't be able to reconcile the credits with the tiering of the entities up to the taxpayer. But most tax cases are just good old-fashioned errors. And the great thing about the tax tribunal is once you file, there's an audit, just like in the U.S. tax court, there's basically a remand. In Georgia, it's formal. It's a 90-day remand to give the department a chance to try to figure out what the heck is going on. Most cases evaporate. But at the end of that remand, you can go forward. And again, believe me, the department does not like to show up and have the judge look at them and say, now, will you tell me again why this is a problem? So the great thing about both the tribunal and OSA is that OSA, it's a great place to get a resolution. And I'll talk about that further. Now, again, you don't have to refer to my outline, but when I refer to OSA, everybody, by the way, confuses us with OSHA, with this Office of, Office of Safety and Health Administration. OSA stands for the Office of State Administrative Hearings. Our full title is Georgia Office of State Administrative Hearings, aka OSA. And you look us up the website, which is in the outline. The tax tribunal, and this confuses people, Administratively, the tax tribunal is an administrative unit of OSA, but it's very different. For instance, tax tribunal is actually a court of public record. OSA is not. Our files are open, absent statutory provisions or other limiting factors. But we're not a court of record. Whereas the tax tribunal is a court of record and is supposed to maintain a copy of its decisions and post them on the website, et cetera, et cetera. So in that sense, we're very different. But administratively, it's budgeted and run through the OSA budget. The OSA judge can sit as an OSA judge. Judge O'Neill sits, for instance, he has Houston County as his district, and he sits there. When I was on the court, I had Augusta. And one of the great things about that is it gives the judge an opportunity, quite frankly, to get a lot of bench trial time. Because fortunately, as you know, most tax cases don't get tried. They get resolved. And I'll talk a little bit about the approach to administrative cases and that regard. Again, if you look at the outline, you can see OSA has some very, very impressive stats in terms of its efficiency. And the other thing that's very interesting that is a similarity between OSA and the tax tribunal is if you know the US tax court system, you know, you have the regular cases, and then you have, I think they call it small claims, David, isn't that the term they use? Or the small case group, but it's on my recollection, it's like cases under 50,000 something. That kind of, those cases, and that's the bread and butter of the Georgia Tax Tribunal. The very few tribunal cases involve more than 50,000 in tax. As a consequence of that, you have this expedited, very administrative style hearing procedure, which is a final decision. It's not appealable. But those cases are almost, the vast majority of those are pro se. The same thing is true for OSA. Over 80% of OSA's cases are pro se. We do have cases with counsel, but we have a lot of pro se cases. And one of the things here, and this is, by the way, something I think lawyers can and should use in their negotiations with whether it's the IRS, the Georgia Department of Revenue, or with the administrative departments of the state of Georgia. When you are dealing with an institutional governmental litigant, it is not like dealing with a proper, a private party. Private parties have entirely different incentives. Wars of attrition rarely make sense with the government. Now, that's not necessarily true anymore with the IRS, which is stretched to the max. But, you're not going to get a better result because you drag your case out and engage in a lot of discovery in, generally speaking, in an administrative case or in a tax case. Again, they don't have infinite resources, but they're not going to, they're not having to send a bill every month to justify how much time they spent on the case either. So what makes the government settle? What makes the government want to resolve a case is because the government realizes it's and duty. In fact, their advisory, I don't have these cited, but there are actually opinions out there that remind particularly prosecutors, it is not the primary goal of a prosecutor to get the conviction. It is the primary goal of a prosecutor to get the correct result. The same thing is true with government lawyers in civil litigation. The duty of a government lawyer is to get to the correct result. I must tell you, my experience with the lawyers who appear before me in OSA and the ones who appeared before me when I was at the tribunal is they get it. They really do understand that they're supposed to get the result. Now, obviously, reasonable people can differ about the right result. That's why we have court systems. But it never hurts to remind the agency you're dealing with is about, look, this really is the right answer. you know, this really is the right answer, and here are the reasons it really is the right answer. It's not about equity, because tax courts and administrative courts are not courts of equity. They're courts of law. What do the rules require? Having said that, if you inform your argument with, here is what the rule of law requires, this is why my answer is correct here. That's always effective advocacy. It's also, I think, the correct thing to do from a professional point of view. Another thing to remember is OSA and the Tax Tribunal are non-jury courts. You're not going to impress us with your flamboyant arguments. I mean, Judge O'Neill, those of you who know him, is a former legislator. He's been around a long time. He's heard it all. You know, you're not gonna snooker it. The same thing is true of our OSA judges. That not most of us, a lot of us are alumni from large firms. We have, but everyone there has been in the, you know, done it for years, been around there, and we're not going to be impressed by what might be a cute stunt in front of a jury. Having said that, the other thing that's important to remember is that don't waste time. And again, you know, the U.S. tax court has a really good system and pretty, you know, and it moves cases along by and large. I think that one place, if I had to be somewhat critical of the U.S. tax court, what's scary is when you start reading decisions written in 2022, and you see the date of the case in issue is like, you know, 2004. And you're saying, wait a minute, this case has been going on how many years? I'm a great believer in the old dictum that justice delayed is justice denied. One of the great things about OSA and one of the great things about the Georgia Tax Tribunal is cases don't linger. They get moved through, and that is the right answer. So, and how does that get done? Because we're not going to waste time on discovery disputes and things of that sort. Now, the Civil Practice Act discovery rules do apply to the Tax Tribunal. In the OSA cases, there's no formal discovery. You can request discovery, but basically you have to rely on freedom of information requests and basically what your record is. So fortunately, we don't normally have paper wars, but so things move along. And OSA, and another thing is, OSA in particular, during the pandemic, OSA is not behind. We never got behind. We, again, Judge Malley did a terrific job. We basically, in 90 days, had gone to fully virtual hearings and fully virtual calendars, and we cleared our calendar. We are not behind, never have been behind. I was talking with David before we started this program today. One of the things I personally am interested to see and think is a good thing is that I think virtual is here to stay. I think for many of the cases we have to hear, the issues are not generally factual disputes. That's often the case in tax litigation. Literally, it's getting the record developed and saying, you know, here's where things went. Here's the issue, Judge. This is what you need to decide. If there is a factual dispute, it tends to be a narrow dispute. It tends to be a dispute about valuation or, you know, something very specific. So there's absolutely no reason that 90% of the record can't be developed by stipulation and be submitted. And again, I think that that's the norm, and I would encourage you to do it. So what's the message here? The message here is it's not in your interest as a litigant, nor is it professionally responsible to play games with trying to hide the ball and documentation and surprises. And I know Judge O'Neill takes a dim view of it, and I take a dim view of it. So don't do that. what you need to do is try to move forward and get it done. Speaking of which, going back to virtual hearings again for a moment, a little bit about that. I'm a great believer in them. I have tried a number of fairly complex cases with virtual hearings. They are terrific. I actually prefer, it's funny, as a judge, one of the things I really like about it is I can see the witness's face looking square on, as opposed to listening to him from the side. And I find it very instructive. I think it is incredibly efficient. I think it's crazy to have 6 people schlep down to, by the way, OSA's offices are in the 225 Peachtree Center building, suite 400. But it's silly to make people schlep down and sit at OSA for 2 hours to testify for 30 minutes about something that, you know, they can do perfectly well by video. I will rarely object if a party wants to appear virtually, or if a party wants to have witnesses appear virtually. Works fine for me. In rare circumstances, I will order, the rule is that we can only do a full virtual hearing if both parties agree. However, what's an in-person hearing? An in-person hearing in OSA is I show up, and if the lawyer for the petitioner or the department shows up, that's in person. I can allow everybody else to appear virtually if I choose to do so. Now, I warn people about that. There are also times when you want your client to be in the room. One of the things we do quite a number of cases about are what involve benefits. That, you know, Georgia at OSA, we have, some of you are probably familiar with, well, we have like the Medicaid waiver for people who are financially unable to pay their bills can qualify for Medicaid in appropriate circumstances. We have a number of disability programs, the so-called NowComp waiver, which is for people who are physically disabled and need immediate assistance. And we have a number of DCH hearings that involve that. If your client is the case, you need to have your client show up. One of the things I try to warn my pro se litigants about is they'll say, well, I can't get to the courthouse. I say, you know, ma'am or sir, that is your decision, but let me encourage you to try to come, because I have seen this happen many times. I have seen the petitioner to show up, and I have seen the lawyer from the Department of Community Health to show up, and they talk a few minutes and they say, we need to work this out, because what they are seeing is a human being as opposed to a report. And they realize there's a more serious issue here than one might think from a record. So those are some thoughts about virtual hearings and virtual testimony. So, what is professionalism? David, again, has included, a lot of good material on it. And Justice Clark really was, when you hear these, I had to, I'm sure y'all were like me, I had to do my CLE last year, all virtual. And I listened to a couple of ethics things. And it's very interesting. The out-of-state speakers always talk about Justice Clark and his efforts to initiate the whole professionalism movement. But there are certain, continuing concepts that we shouldn't have to remind people of, but we need to remind people of. And they're just a couple of bullet points. And this is true for all litigation, but it's particularly true for administrative litigation. First of all, is courtesy. There's absolutely no reason. One can disagree without being disagreeable. There's absolutely no reason to be a jerk. It is counterproductive. I won't tell you who, but I am really annoyed right now with a case I have that is actually a very substantial case that is, interestingly enough, a tax case, because one of the few kinds of tax cases that go to OSA that don't go to the Tax Tribunal in Georgia is unemployment tax. Now, you might want to know why. Well, the answer is by federal statute, for reasons I don't quite understand. Unemployment tax cases are confidential through the trial level. If you appeal them, you basically lose appealability, you lose confidentiality, but at the trial level, they're confidential. Well, I've got an unemployment tax case going right now, which involves an issue called successor liability, which those of you who are tax lawyers who work in the M&A world know about this, but you may have learned the hard way. Because when an acquirer acquires a business, depending on how you do it, the acquirer may have to qualify for the initial unemployment tax rate, which is normally higher than the rate that you would pay if you have an ongoing enterprise. And it reflects, again, those of you who especially like you manage a firm, one of the things you want to do is make sure one of the disadvantages of firing people is your unemployment tax rate goes up. Okay. Successor liability turns on, it's a pretty complicated test. And on this case, it's significant money. And we've got real lawyers who are from out of town and who so far are not showering themselves with glory. And they have gotten crosswise with the lawyer for the department. And I am sort of about ready to, declare a plague on both their houses. And the next call will be, okay, we're done. Y'all we're going to have this case on this day. I don't care whether your witnesses can be there or not. I don't care if you're prepared or not, but I'm going to issue an order and I want you to stipulate to da. And if you don't, I will not let him, I can play hardball when I need to. That is not the way to handle a case. It's not going to redound to the glory of either side, nor is it likely to improve the likelihood of their prevailing on the merits. Don't do that. Don't do that. By the way, OSA now can issue sanctions. I've issued a couple. We can actually now fine and enforce. So, and I've had a couple of situations where I've done it, and I've had a couple of situations I almost need to do it. Our subpoenas are also subject to enforcement by sanction now too. Okay, let's see what else I'm going to talk about. Back to my scrolling here. What did we do before computers? Answer, we did this. Another thing. I had a classic case this other day. I have a very interesting case right now, which again, OSA cases can be small, but they can be substantial, involving pharmacies, and it's a huge Medicaid chargeback. Again, those of you who know the healthcare industry, basically Medicaid can go back and contest for like 3 years and say, well, we really shouldn't have paid that claim. And they hire these auditors who are on a commission basis, and they go back and do it. And then you end up with these cases about, well, was this medically necessary? I've got one right now involving prescriptions, and it's a lot of money. Well, one of the things here, it was very interesting. The lawyers for the pharmacy company did a terrific job. They did an absolutely terrific job on their issue. They got their documents, they had their arguments, they laid it out, they made it easy. And in the case in question, there were actually 52 separate claims which had been combined. The lawyers for the department, basically, and David, this is sort of like, the conservation easements. The department didn't fight it on the merits, they're fighting it on a technical issue. Well, one of the issues the burden is always on the department, it's on the government. The government is the burden. In this case, the department did not lay out its case of the 19 claims. There were only 4 that there was testimony taken on. Well, let me tell you something. I haven't decided yet, but the government's got a problem, pretty serious problem. So the key is I cannot stress the importance of any kind of case, any tax case and the like, cannot overstress the importance of having it all together, having it organized, and having it easy to use. Also, if you have to try a case, please do not rely on the fact that it's in the computer. Because if you do, you will spend another 2 hours in the courtroom while the judge scrolls from screen to screen to screen. This is one place where you cannot beat paper. Show up at the hearing with a hard copy of the exhibits, tabbed, paginated using bait stamps by every page, so that everybody can literally be on the same page throughout the hearing. Computers are wonderful, but this is not one of their fortes. Another thing is do not, and I stop, I don't stop. I always start every hearing with this. I say, before we begin, have you exchanged your documents? Well, sometimes I'm stunned when people have not exchanged their documents, which, by the way, is in violation of the order which notices the hearing, which says you're supposed to exchange them at least 2 days in advance. But I say, well, let's exchange them. And then, is there any objection to the admissibility of the documents? Now, sometimes if I've got pro se litigants, they'll look at me and you can tell they're nervous. I say, look, let me explain something. Just because the document's in the record doesn't mean it's true. You are perfectly free to challenge what the document says. It's just whether it's in the record. And unless you are going to tell me that it's not a correct copy or it's fraudulent or whatever, you know, we might as well admit it. Because, by the way, in administrative hearings, the standard of admissibility, as you all know, is extraordinarily broad. And again, we're all experienced judges, and we know, I know when something may or may not be believable. I know when something has a tenuous history. So don't fight over issues unless there's a real issue. Now, I'm also the flip side of it is there are times, it's very interesting. I'm involved in a case right now where there's a document which has notes on it. And one of the salient questions is, when were the notes added? And that's an interesting one about what do you do? Because the document is in, or it's going to be in, but the question about how do you challenge the details of the modifications of the document is always good to know. Another thing is in both OSA and the Tax Tribunal is use the administrative staff. Judge O'Neill has a clerk, and he has a basically administrative assistant who manages things. You know, if you need help on something, don't hesitate to call and say, how do I do X? How do I do what? The same thing with OSA. One of the things I always like to say is, please call before you write. Sometimes I get lawyers who what I call motion happy. And yet OSA, by the way, does have a rule that we will not entertain a motion unless it's in a formal written motion. Okay, that's statement one, and it's a good rule. And that's designed to prevent people from sending in emails and saying, oh, well, I asked for that. Okay. But the flip side of it is before you file your motion, it never hurts to call. And I have three people who help me: Rachel Braddock, who helps some of my calendars, Devin Hamilton, who does others, and Chelsea Unschuld, who does others. It never hurts to call and then also we don't have clerks. We have what are called case management assistants. And when I say clerks, I mean like good old fashioned, clerk who stamps stuff in. But the case management assistants are the ones they will answer and say, they can respond a lot of times, or if not, they'll check with me and I'll say, well, they can do X, Y, and Z, or do we need to get on the phone? Because again, like discovery disputes, I do not want to get a motion on discovery disputes. I want to talk about it before I get any motions and see if we can get it resolved. If I actually have to rule, then you can write one. Now, another thing is, of course, lawyers, this is I used to be early bird, and the older I got, the later last minute Charlie I was. If I didn't have a deadline, I couldn't get anything done. I still am that way to some degree, but don't wait till the last minute. Do not wait until the hearing to exchange your documents. Exchange them beforehand, exchange them way in advance, get them organized, see what you can stipulate, identify what you can stipulate to, and be ready to roll. Let's see what else. I think those are the main things I want to talk about. I do want to stress, I want to go back to this problems resolution thing. One of the great values of getting your case either to the tribunal or to OSA is the fact that it forces the parties to get serious. I have become Judge Malley. One of the things at OSA, and I get on my lawyers about this, because, the lawyers will keep asking continuances. And I say, well, first of all, I'm not supposed to do it unless there's a good reason. Secondly, if you stay on there, I get on the bad list. We get printouts and saying this case is old. What's going on? The other thing I have learned is if you want to get a case on the calendar, put it on the trial. If you want a case resolved, put it on the trial calendar. I think every judge knows that. And so I'm only going to put up with, delays for a reasonable period of time. Obviously, in administrative litigation, and again, to some degree, I think in the tribunal, taxpayers, when they're pro se, we understand they're doing the best they can. I understand I'm going to get stuff. I got a motion for reconsideration today that was handwritten, which was really hard to read. And I'm going to have to deny it, but it was a legitimate, and I told them, I said, we'll send this in and I'll look at it. But we're going to bend over backwards for pro se petitioners, and we're going to cut them a lot of slack. The same is not true for the department. If the department's supposed to do something, the department's supposed to do something. And so we will be, I'm pretty tough on them, but I'm not going to be unreasonable. And that's the last thing. We all try to be reasonable. And ultimately, we're all, I know OSA is not a case, not a court. And the Tax Tribunal is not a court that rejoices in getting rid of cases on technicalities. Having said that, and this goes back to malpractice, the most obvious and fundamental cases of malpractice are missed deadlines. And you would be stunned at how many there are. And you do not want to be in a position, professionally or ethically, of being in the position of having to tell your client you missed a deadline, and that therefore you're about to have to spend some time, getting the judge to reopen the default, or to, take a motion for reconsideration, or whatever the issue is. So you really, really, really don't miss deadlines. Again, in the malpractice area, David and I used to and we used to talk about this when I was at Morris Manning, and I'm giving a read opinion on a $500 million transaction, and they're yelling about will versus should, and yelling about this and yelling about that, and we're all sweating bullets and we're all agonizing over it. That's not the case that's not going to be the malpractice case that you're going to lose. You may be embarrassed, but you're not going to lose, because everybody's too careful. There's too much that goes into it. The case you're going to lose is going to be the case where you didn't file a form that was required. David mentioned 83Bs. I used to say, without a doubt, I used to say, if I could do one thing, I would have a banner headline as you walked into the lobby that said, do not forget to file your 83B election within 30 days of receipt of interest in the property, because everybody thinks it goes on the doggone tax return. And not only do not forget to do it, there's 3 versions of it. The government finally backed off and said, well, you can get 2 out of 3, but the main one you have to file. In the bad old days, it used to be that the bleeding area of malpractice was Miss S elections. The government's gotten so gentle on that now, I almost think it's to the point that if you sort of meant to, they'll let you off. It's not quite that simple. But even then, you're in the embarrassing position of having to go to your client and say, oh, by the way, we need to do all this. And by the way, if your client is smart, say, and you're not going to charge me for all that work, are you? But those are the kinds of basic malpractice. Let me close, because I got about 10 minutes. And then I'm happy to, David, I'd love to hear any of your rejoinders to anything I've said. One of the things that is the most difficult thing about both malpractice and ethical behaviors, as David said, ethics are what you have to do. Professionalism is what you should do. One of the most difficult things about both the ethical and professional requirements of dealing in the tax world is what do you need to do to give the advice or take the action? And it comes under the heading of what is, in the word we all use is phrase is due diligence. It is very clear that you cannot give advice.
Your last question to Liz, and I'm trying to see if my earpods pick up. I have no idea why they're not. But so I think it's funny. I was trying to talk to you. Oh, well, yeah. I was trying to, like, I had the earpods in my ears, and all of a sudden I'm talking to you through those. Anyway, so your last email to Liz, I think that would require, like, to do something to the document as to who the successor is.
No,
would require, I think, a decanting.
yeah, that's not what I meant by that. So sorry if that. I really meant in the relevant document. Now that I'm seeing,
I think somebody got on the,
I think somebody clicked their mute button, and I think that, hey, hello, somebody out there, I think I'm listening to a privileged conversation, so you probably need to mute. David, did you fix it?
I think I think we're good.
Okay, good, sorry. But the issue is due diligence. And this is the issue. And there also, there's advisors, there's advocates, and there's tax preparers. One of the problems with the issue of when you're doing advice is the issue of how much diligence did you do and what was the requisite standard. And again, going back, and this has been true, and this is where you get, first of all, the government will go after you. And not only that, your client will go after you. Because if you give advice and you didn't get the factual underpinnings that are necessary to give the correct advice, and the client suffers, then that's malpractice. And so it is a dangerous thing. I will say one thing, I think we lawyers are actually better off than accountants, because and I've seen this happen. I once had a great client, just a great guy, and the client, I almost called my name, that would have been nothing. But the client was an experienced accountant, very knowledgeable, bright guy, and was basically the in-house CEO, COO, tax guy for a very successful family office. And he had, if you'll forget, he had a sort of, not very good tax account. And every year he would call me and he would just lose his religion over why he was having so much trouble getting the tax returns in final form. And I at one point said to him, client, or Mr. X, why do you keep Mr. So-and-so as your tax accountant? And the answer is, well, he'll do what I tell him. And it wasn't said with any cynicism or rancor. It was said with just, that's the way it is. Well, I have recently had circumstances where I have seen tax advisors who have made what appear to be egregious mistakes because they just believed what their client told them and they didn't check it. And for instance, what if you ask your client to basically fill out the return and send it in, and you don't look at the K-1s, and you don't look at the 1099s? I mean, how far do you have to go? And that may sound like, well, of course you have to look at them. Well, the answer is that doesn't always work, because sometimes you've got very convoluted, detailed factual information. I don't have a simple answer to the question of how much due diligence do you need to do? But I warn everyone that, and this is true, by the way, not merely for tax litigation and not merely for administrative litigation, but it's true for all kinds of litigation, in case you haven't been following the sanctions that have been issued against some of the lawyers that challenged the election results without adequate due diligence to substantiate the allegations contained in the complaint. this is, I mean, it's real. It's real. And you don't want to be in a position of not knowing the facts. You do not want to be in a position of your case in front of any judge where all of a sudden it turns out that the other side, nails your client. So you really, really need to make sure you do your diligence and your preparation, and you need to approach it with appropriate skepticism. One of the great dilemmas for advocacy is, I forget who said this, but I think it's true. An effective lawyer first has to convince themselves they're right. I think that's true. But before you reach that stage, you have to make sure that you have the facts and you've done the diligence to convince yourself. So and by the way, that's the core of professionalism and ethics, both. You can't leave your good judgment on the coat rack. You've got to use it, and both professionally and ethically, and for your long-term success. So, all right, I think I'm almost close to the end of my time, David. David, I've kind of yammered away. Do you have any further reflections based on what I've said?
No, I agree with that. Obviously, thank you so much for taking the, I did my video. Thank you so much for taking the time to, the world was a better place before computers. Thank you so much for taking the time.
Yeah.
I totally. No, go ahead.
You have to take the bitter with the sweet this morning. I find Facebook, like one of the most frustrating things on earth. But today I had one of those wonderful experiences when somebody put a picture up from something 20 years ago. And I said, this is why I look at it. Because, it's like all things. There's a sword. Everything has a dark side and a bright side. Computers have their bright side, but they have a lot of darkness to them too.
No, you're right. No,
All right, well,
thank you. I think we had one question. We had a question. Thank you very much for the question. Do you find the IRS is taking a reasonable approach to reviewing tax opinions? The few opinions I've had reviewed, I've never had an issue with the IRS. I think unless you're really just giving an opinion on a sham transaction, or as Chuck said, did not do due diligence to ascertain the facts, as long as you've got it's reasonable basis, not 314 ABA reasonable basis, but it's a well-reasoned, thought out opinion, you're not going to get in any trouble with the IRS. That's at least my experience over the years. And I think that gives us, I think we're at about 2:00. I want to thank everybody for participating. Thank you for attending. We put in for an hour of ethics and an hour of professionalism. And in the past, we've gotten that since we actually talked about ethics and professionalism for 2 hours. I would think that we would qualify. But thank you all for taking the time to spend a couple hours with us this afternoon. Thank you.
Y'all take care. Thanks. Bye.
This concludes today's meeting. Thank you for joining and have a great afternoon.